Hi everyone. Thanks for coming into powerpolitics.com. I want to review a little bit about what we went through and continue on with our little understanding of how the Constitution works and how to work it. We started out, we defined the court, we defined sovereignty, we defined political. So now we're getting a perspective of who we are and how we're approaching government, because we are the ones at the top, so we have to know how it works and we have to make it work. And we know from sovereignty and political that it's the paramount control of the Constitution and the frame of government, which the sovereign has, and the sovereign is the court, the suit of the sovereign. The court's defined as a place without walls or within walls and a roof. So basically we're the chief justice of the court, and if we don't act, then the judge or the magistrate's going to act for us. So now we have this perspective, we know who we are, we have to know more than the judges and lawyers as far as process and the laws, which we have to read the Constitution so we know what our rights are, and they're in the Bill of Rights. We have to understand that the Constitution is the supreme law of the land. It overrides all federal and state law. So if an agent of government tells you that there's something that overrides the Constitution, then that would be the time to set them straight, because we have to understand this. We also want to understand that the agents of government take 2 oaths, and those oaths are diametrically opposed. And so the oath to protect the individual's rights is secondary to protecting the corporate rights and revenuing the individual. And that's the way it starts, and the only way to turn that around is for the individual to remind the agent or bring up the agent's constitutional duty to that individual, and then the game can change direction. And we've had a few people that have tried it. They personally know that when they bring up the Constitution or ask an agent if they took an oath to uphold the Constitution, that the demeanor of the agent changes, because he has two promises he has to keep, and he's going to keep one always before the other. And that's natural because he's getting paid to do one and not the other. The other one is duty by voluntary. That's to us. It's voluntary to us, so we have to remind him. Okay, so once we have our perspective, we're in the real world, and then we interact with an agent, and maybe they don't like what we're doing, or they try to challenge our position, and what do? They give us what's called a notice to appear. Okay, so we get a notice to appear from an agent, and when we sign that notice to appear and decide to go to the court, what has actually happened right there is we just lost. Because the agent is saying, I'm going to represent you to the court as speeding or as running a stop sign. And if you don't object to that, then that's how I'm going to represent you to the magistrate. And when we get there, I'm representing you and to the magistrate with these facts, and you've already had a chance to rebut them right here at the window, but you didn't. You agreed with me and you signed to appear. So now once you've going to go appear at the court, you've basically already conceded that the officer was correct in his idea that you were speeding or whatever that was, and he writes it down in a code, so only they know, and he puts numbers down, and as if that's the law that you broke. And so already we're starting off on the wrong foot when we get to the court. So now if we go back to our definition of the court and how it works, when we get to the courthouse, we're gonna want to know which court we're going into. So basically the courts are divided into 2 jurisdictions at first. Basic overall there's a criminal court and a civil court. And that's all there is, criminal and civil. And so when we walk into that court with a notice to appear, when we go to where they told us to and we sit down in what they call a traffic court, we still have to ask ourselves, is this civil or criminal? And we know that each case that goes into any court has to have what's called a cause of action. Now, cause of action, you want to look that up in your Black's Law Dictionary. And my first thought when I hear cause of action is right to relief. So when I go to court, if I'm sued by an individual, they would be suing me because I did something to them, and they would be the ones who are entitled to the relief, and that would give them standing to sue. So now in a criminal case, the cause of action would be what we call a warrant. It would be the cause for the agent to act, the cause of action. What causes the agent to act when he stops you for a violation? Well, it's going to be either a warrant, if it's a criminal action, but it could be a personal violation against the officer or agent, and that would be a civil action. So we have to determine when we get to the court, criminal or civil. Now, in one respect, because you're written up with for a infraction, misdemeanor, or felony, those would be considered criminal. So you would think right off the bat you're in a criminal case if you are charged with a felony, misdemeanor, or infraction. However, when you get into that court and you want to know who's charging, we find out that it may not really be the agent that's charging. He may be just a witness, and the charges may be being brought by maybe the people of the state. Now, if it is the people of the state, then that would be the party who would have to be entitled to the relief in order for there to be a cause of action. So this is where these courts, they act upon a claim that's not sufficient. And the reason why it's not sufficient is because there is no cause of action on these complaints. Because if there was a cause of action in a criminal case, there would be a warrant for the arrest. In a civil case, you would be served with what's called a summons. So in a criminal case, there's the warrant and the complaint, and then of course it would have to be an indictment by a grand jury according to the rules of the Constitution. And in a civil court, you have a summons and a complaint. Now, when we study a little bit deeper, we'll find that they consider the summons, the notice to appear, a summons called short form summons. And they put in all these short forms and all this easy way so that we can get into a criminal case and then be subject to revenue. But as we look at specific definitions of what a cause of action is and who's entitled to the relief and what standing is, we find that the court hasn't been put together properly. And that's what has to happen. The court has to be put together properly. And that's why we have to understand how the court works. We have to understand the rules of the court. We're going to learn the process of the court and the language, the words, and what they mean. Very important to understand this language. So I recommend that you get a Black's Law Dictionary and you take the perspective of a sovereign, and we move forward to use the language, the process, and the rules to our advantage, because it's set up for our advantage, because we are the sovereigns, and that's the mindset that we want to have. Okay, so next time we'll talk more about due process and how that fits into the mix. Thanks a lot.